To the first kickoff distinguished lecture in intellectual property. And this is a really exciting day because not only do we have a distinguished speaker, and not only is it our first distinguished lecture in intellectual property, but it is also the launch of our Center for Intellectual Property Law. And so I'm very excited about doing that, and very excited that Professor Irina Monta, made all of this happen. So I thank you, Irina, for that. And a lot of people here, a number couldn't make it because of the snow advisories. It's hard to believe that we still pay attention to them. But in this neighborhood, it's supposed to get anywhere from, I don't know, 4 feet to 11 feet. 4 to 10 inches by tomorrow. It was 40 today, and now it's about 28, and so it's a little bit messy. So thank you all for coming in. Susan Fortney actually flew in the whole way from Hawaii just for this, so we thank you for doing that, Susan. Although perhaps excessive, it's the kind of wonderment we love. So thank you. So during my deanship, the law school has, really focused a lot on trying to better connect our students and alumni through externships and mentorships and programs and networking receptions. And one of the ways we really have done it, and actually Irina has shown us how well you can do this, is through creating centers like this one, which gives our students an opportunity to work closely with faculty and research and scholarship and gain experience, but also to be mentored by alumni in those efforts and to relate and meet with alumni on a more regular basis. The center provides this opportunity for us, and not only that, of course, good centers build the reputation of the law school, and we're always interested in doing that. So your efforts, Irina, to take charge of this effort and to build this IP community with students and alums and guest speakers, and your colloquiums, which bring in people from all around the area on a regular basis to speak upon this really exciting field of intellectual property, has really been great. And these efforts really got, if any of you were there, we were at Bryan Cave for this law firm for the second annual alumni reception of students and alums, and I think there were like 75 people there. And that was a wonderful thing, and it was nice that the law firm paid for that. Or maybe we did. And also, you've been able to, raise money for speakers. It's just been extraordinary what you've done. And while at the same time we were writing articles galore, published in Ohio State Law Review, Florida Law Review, and Iowa Law Review, to name a few. So you really put the shoulder to the wheel, as we say, for the IP and Hofstra cause. So we thank you for that. And by the way, she's also co-authoring, I don't know if she has time for this, co-authoring a forthcoming textbook. The kind of things you got buying in class, $127, 1,100 pages, and then sell back the right way the next year. It's in criminal law issues in intellectual property, and it's entitled, as you might imagine, Criminal Law, Intellectual Property, and Information, Cases and Materials. And this past year, she also, while she was doing all this, she received the Lawrence A. Stesson Prize for Outstanding Scholarly Publications, which the university gives to 2 young junior faculty members every year. So we already congratulated them. So we're not doing it again. So I myself am really, really excited about the importance of this center, both to the intellectual life of the school, to the opportunities for students to connect with alums and to find work opportunities, and for the wonderful glow to the reputation that such a center presents. So I'd like to introduce everybody, to those you don't know, or most of you do, Irina Monta.
Great. Well, thank you so much all for being here despite despite the weather conditions and everything. So I want to thank Dean Lane for his remarks, and along with the law school and Hofstra University, thank him for making this SIPL possible. It's my pleasure to serve as the inaugural director of the center, which will house our existing programs, as Dean Lane described, and will serve as a forum for research and discussion into the field of intellectual property. Professors Akila Fulami and Leon Friedman will join me in this center. They will be affiliated faculty along with them and a number of adjunct professors. Our school offers a rich curriculum to our students across the areas of copyright, trademarks, patents, entertainment law, cyber law, biotechnology, and many others. The last couple of years, as the Dean mentioned, the IP Colloquium has hosted a number of speakers. We've had close to 20 speakers from all over the country who have talked about the constitutional, law and economics, administrative, policy, and public health dimensions of IP. This last year, we graduated our first batch of students from the IP Law Honors concentration, and we're looking forward to continuing doing that the next couple of years. We've run a whole bunch of programs, our one-on-one IP mentorship program, where alumni help students succeed in the field, and we've had our annual IP reception twice now at Bryan Cave in the city, which has been a great opportunity for our community to get to know one another better. The SIPL is going to have a number of important goals. First, it's going to create scholarship and other writings on the complex IP law and related issues that confront our world today, be they in the creative industries or in the technology sector. Second, it will connect faculty, students, and alumni in the quest to understand and explore developments in the IP field. Third, it will promote professional development in the Hofstra law community and the legal world at large, and we're very excited about pursuing all of these goals. The SIPL is lucky to have two special assistants that I'd like to introduce. If you would get out, Stephen Breidenbach and Ashley Flynn. Ashley assists with the general activities of the SIPL, and Stephen has been the main designer of our new website. So it's a designer website which you can doing a really great job and a lot of work. You can visit our new website at hofstralawsipl.org, and we'll keep our events there. You're going to see a recording of tonight's event there, news about everybody in the IP community at Hofstra, and there will be a collection of the IP resources that the school offers. You can also join us on Facebook or Twitter at the handle Hofstra IP Law. This fall, the SIPL will welcome its first group of IP Law Honors Fellows, who will be high-achieving students who have demonstrated an interest in IP, and these fellows will become integrated in the life of the center and will be mentored to success by our faculty and alumni. So speaking of alumni and other friends of the law school, there are a number of people that I want to thank for making tonight's event possible, and that's our donors. First and foremost, the law firm of Lattice & Perry, which has been a big supporter of our program and of this lecture. And then also individual alumni, Avery Hasen, Anthony Coles, Scott Foreman, Joshua Bortman, Patricia Clark, Jason Mencher, Tyler Evans, and Angelica Harden. These are the people that made tonight possible, so we thank them. Before I introduce our speaker, one last thing. I want to already give you a preview that we'll have another important event on April 21st at noon, a panel on IP and eminent domain, which will host Professor Clarissa Long from Columbia, Professor Gregory Dolan from the University of Baltimore, and eminent domain expert Professor Ilya Somin from George Mason University, and myself. So we'll be on this panel together at noon on 21st, and you'll get more information about that, and it'll be featured on our website. So now, without further ado, I want to introduce Professor Robert Merges. It's a great honor to have him with us today. He's the Wilson Sunstein Professor of Law and Technology at UC Berkeley, Boalt Hall School of Law, and the co-director of the Berkeley Center for Law and Technology. He is one of the best-known scholars in the IP field in the country and world, I dare say, and has published several books and numerous articles on the subject. His articles have appeared in venues such as the U Chicago Law Review, the Arizona Law Review, Texas Law Review, Harvard Journal of Law and Technology, California Law Review, Houston Law Review, and our very own Hofstra Law Review. In 2011, Harvard University Press published his book, Justifying Intellectual Property. He received his BS from Carnegie Mellon, JD from Yale Law School, and LLM and JSD degrees from Columbia Law School. And with that, let's welcome Professor Merges.
say well, first I want to say thanks for everybody for being here. I jinxed the whole thing when Professor Mehta asked me if I would come and give this lecture. I said, yeah, just promise me there's not going to be any snow. And this was probably, I don't know, last August or something. It's all on me. I'm terribly sorry. But I appreciate everybody being here. I know that it's not easy to make your way, especially after the end of a long day of work or school. The warmth of the hearth beckons, and all those dinners to be warmed up and reruns to be watched on TV. You're giving all that up for me, so I very much appreciate it. But I have to say, after listening to the introductions, my very strong impulse was to say, you know, I just want to sit down and hear Professor Mehta talk. She sounds fantastic. And what am I doing here? Anyway, we do what we can. I'm very honored to be here. I want to just say that these Centers for Law and Technology, as the a touchstone of the community, are extremely important. We have found ours at Berkeley to be incredibly rewarding, and I think the community that you start to build around the field is a big part of what these things are all about. So you guys should feel good that you're underway on that. When they work well, they really bring people together in this fascinating field, and they provide I think intellectual refreshment and encouragement for practitioners. They provide job opportunities and training that you can't get in classrooms to students. They enrich the faculty. They're just overall a really good thing for law schools that put some effort into them. So I'm always a big fan of supporting them. It takes a lot of effort to do it. It's not something that academics are directly rewarded for. So as much as you've heard Professor Mehta's publishing, know that to build a center like this, she's putting a couple of those possible publications aside and giving them up, because what it takes to build a program is time and effort. I think it's worth it. It's certainly an investment in the school and in the future. But know that the rewards are more intrinsic and not always immediate and direct. But this one's directed at you, Dean, which is you can make them a little more direct by making sure you give her credit. That's not always easy. Okay, so anyway, enough lobbying for the IP field. I can't help myself. Here's what I'm really going to talk about. Just going to talk a little bit about some basic theory, which goes to why is intellectual property property. Always an interesting theme, and people in the IP field wrestle with this and have over the years. I want to apply it to some very specific issues, particularly talking about online content. So my title was kind of a teaser, which is everybody knows that trying to make a living distributing stuff digitally has become very challenging. I just want to talk about how I see the market for online content and what the role of law is here, especially the way this field has evolved, the way digital distribution has evolved. I think we have, in a sense, gone back to the beginning, the early days of the internet, and I'll talk a little about that as I go along. In particular, I'll just give you a little preview, which is, we talked a lot in the early days about the internet. We said it would disintermediate, it would take the middle layer, the middle people away, and would put creators directly in touch with their audience. Anybody who remembers all this buzz from 1995 through 1999, you remember what I'm talking about, right? We're going to disintermediate. We're going to take the legacy intermediaries, the publishers, the record labels, the broadcast companies. We're going to get them out of the way. The internet's going to be this magical medium that automatically and immediately connects authors with their audience. What we have discovered over the years is after that sort of Wild West period, and now living in a world where some direct contact is definitely a part of day-to-day life, but we're experiencing what I would call re-intermediation, except instead of the old middle people, the old middle tiers, the legacy middle tiers, what we have now is the technological platforms. We have the social media companies. We have anybody who has a distribution mechanism, and most important, a payment mechanism. They're the new intermediaries. And so there's been a reshuffling in the world of content as it's moved from the old terrestrial model to online. But in some ways, we've reinvented with a slightly different set of characters, a similar structure. Okay? However, we come out the other side of that in a very different shape in ways that I'll try to explain. So anyway, that's the business model point. And I want to weave into this a conception of legal rules, particularly in the IP field, where we think about them as enabling options, things that you can use if you want, but don't have to, things that give you flexibility, and the way that individual creators use IP in this three-tiered content distribution structure creates a lot of opportunities and a lot of ways for you to think sort of flexibly about how to use IP as part of your sort of overall business strategy, your overall creative strategy. Okay, basic theory. We know IP is a property right over intangible assets. I like to think that the case for property is still pretty strong, because what it boils down to is individual control and individual autonomy over specific or discrete assets. That's really what property is about in a very general sense. And even though the assets are very different, we all know that digital content is extremely easy to copy, that your copy doesn't come at the expense of my copy, that it's hard for me to prevent copy. The whole dynamics of copy are very, very different. But still, at the beginning, there's the single instance of a work that took the initial creativity to create. And that's the asset that we're trying to protect with intellectual property. I had a friend who described the cost curve for intellectual goods as being L-shaped, right? So on the left margin is cost. The first copy is very expensive, right? You think the director's print of a Pixar movie, that's a couple of 20, 30, 50, 70 million dollar piece of production there, right? The first copy is expensive. Every other copy, boom, down to zero. Out to infinity is free. First one, really expensive. Every single other copy, essentially in the world we live in, is free, right? It's essentially free. But it's that initial creation and the conditions that help create it that we need to think about. That's the asset that has to be protected, because that's the thing that's rare and scarce. And that's where property still makes a lot of sense. Property over the individual copies gets a lot of attention. But in a way, it's almost like saying, well, of course, the interesting problem is to divide up the pie. But doesn't that assume the existence of the pie, right? And we can't do that, because creating the pie is what this game is all about. Getting people to make that first copy. That's what this game is all about. So we'll talk a little about that. But I think property still makes sense in that context. The basic framework that I like to think about is we all work, we all labor on things, and in some of our work, we just get paid for our labor, we get paid for our wages. If I'm back in the days when I was making pizzas or cleaning boats and other stuff that I've done through my life, you know, my deal was I'll work for you and you'll pay me for the work that I do, and that's basically what wage labor is all about. The great thing about property is sometimes with some kinds of labor, if we produce a work product that is protectable by IP rights, we can convert that labor into an actual asset, right? We can turn that body of work, that bit of effort, into a thing which can be protected by a legal right. And the great thing about an asset protected by property rights is, unlike when I was making pizzas, unlike when I was scrubbing boats, I get paid sometimes when a student in Shanghai, I think it happens once in a while, actually pays for one of my textbooks, even if I'm sleeping here, even if I'm doing the dishes, right? So it's work that I've put in, it's turned into an asset, but we get paid for it sometimes, under some conditions, even when we're not working on it. That's the magic of property, because it turns that bit of labor into an economic asset that earns rents or profits, even when I'm not actively working, right? And so true with the film, so true with a piece of music, etc. That's a really important, I think, device, because for those kinds of works that are privileged that way, the law really gives you this very special treatment. There aren't that many kinds of labor that we can turn into a property right. But when we can, wow, it's a great deal. Okay. Just to take an example, we know illustrating is work. It takes work to make a decent picture. And we know that sometimes an illustration that's got some kind of a market can be worth something if we copyright it and sell copies of it. Right? So the first effort, the sketch, takes work. That's like any other job we might have. But in those conditions where people might want it, in those conditions where multiple copies might have a market, copyright turns it into an asset and we can make some money on it. Okay? And as I say, you can make money even while you're sleeping. And that's just great. This kind of conversion of some labor into property rights is something that really it gives it a special status. And the point I'm trying to make here is that this is something that for certain types of work, we think it deserves that kind of privileged status. So intellectual creations have a special status. They are protected by a property right when other kinds of work, when my pizza doesn't get an IP right and my boat scrubbing doesn't get an IP right, but my textbooks do, that tells me that's got some kind of special quality or some kind of special flavor. It tells me about the market too, but it also tells me that there's something society thinks is valuable in these intellectual creations. And that's important to me because a property right is a right. And I think about it as a right that makes sense under some circumstances because we want to privilege certain kinds of labor. We just think it's valuable. We think it's important. Inventions, interesting brands, copyrighted works, things like that. And the process of turning that labor into some kind of economic assets, is what I call privatization. It's the process when an IP right attaches to some work product, assuming there's a market and assuming that you can put your product out there on the market. Boy, the IP right gives you that kind of ability to turn that into an asset, which is great. Okay. Another way to think about it is that sometimes we're just employed to create stuff. And maybe the stuff we create, we do that in a corporate setting. We do our little part. Sometimes we're paid to write computer manuals for software companies. I've done that in my life. Sometimes we're paid to write out marketing text or advertising text for a big company. So we might work in the advertising division, or we might work in the technical writing division of the company. And in those situations, the company we work for will take our work and bundle it up with a whole bunch of other people's work and sell it, right? So in my little diagram, I'm imagining I'm creating stuff in this little yellow division here, called division. And I'm part of firm B. And they enter into a contract and sell stuff to firm A. It might be they sell computers along with a manual, or it might be that along with the refrigerator or the set of tires, there's some marketing materials, and that's my contribution. Right? So that's this first sort of diagram. One of the things that IP does is it gives me, and maybe a team of people, the ability to kind of break off from this bigger corporate structure. It allows me to sell my work product separately, not bundled with a bigger piece that the company puts together, right? So in my example, I might move from being a technical writer at a company, a software company, to saying, I think I can do a better job than these guys do on manuals. So I'm going to go independent. I'm going to write computer manuals, Burgess's Guide to C Programming, or Burgess's Guide to PowerPoint slide production. I'm going to do it myself. I'm going to detach from Microsoft, right? To make that possible, IP rights are extremely helpful. Because how else can I sell my intellectual creation unless I can protect it with some kind of an IP right? So you notice in this little story about this division which drops out and turns into a separate company, the effect of IP rights here is that they enable this company really to exist. If you couldn't protect that work product, then you couldn't specialize in it, right? The only way that you could make money would be to be an employee and have it bundled up with other stuff. That's the only way you could make money on it. If I couldn't protect my user manual that I sell as an independent author with copyright, I'd sell one copy, they'd put it up on the net, it'd be out there, that's it, we're done. The way I can make a living as an independent producer is if I can sell my output protected by a property right in some kind of market, right? So IP not only privileges certain kinds of work, but it actually enables some kinds of work to go on in an independent setting, okay? And that's important. If you value your autonomy, if you value your freedom of action, if you'd rather write manuals and take a risk that the market's not very good than suffer the slings and arrows of the same boss that you've had for the last 15 years, if you want to go independent and do it your way, IP is a very nice tool because it allows you to take your output, turn it into an asset, and try to build some kind of company around it, right? So this little story is a story about how IP not only affects my incentive to create, but really my incentive to do it independently. So there's a notion of independence mixed in here too. And I described this in one of my older pieces, and you can look at it if you care. We're going to post these slides, so I'm not going to dwell on it. The reason I emphasize this autonomy and independence is when you survey people, especially entrepreneurs, you find that there are certain types of people who really value that a lot. They value it so much that they'd rather make less money working for themselves than they do in a big company working for somebody else. There's a fair number of people like that. And people like that tend to be people who appreciate the quality of intellectual property because it sometimes allows their business model to function. IP sometimes is the little engine that allows them to do what they like to do. And it just turns out that some of those people are really big contributors to the economy. They certainly are big contributors to their own self-satisfaction, so we don't want to minimize that. But they sometimes make an important economic contribution too. And when they do, we can say that that sort of spirit of independence or starting a startup ends up not only benefiting them intrinsically, they just don't want a boss, but it benefits a lot of other people too. One of the great gratifying experiences in my life was, I did a lot of work over the years on identifying patents and looking at big collections of patents and portfolios. And I had a couple of friends of mine some years ago, we started a company to value and identify patent portfolios. And we started it and actually employed some of my former students, and people were actually making a living on it. Then we sold it out, and it was a good experience all the way through. But the feeling of starting a company and actually, providing a living for people, for Pete's sake, not just blabbing in front of a long day, that was really rewarding. So I can say that there's a lot of value in entrepreneurship as just a life experience. I've lived it myself, and I enjoyed it. Okay. So we can talk about it as something that promotes independence, something that promotes autonomy. What about the question of fairness? Does IP have anything to do with how fair society is, right? You could have a world where, okay, sometimes people have to work for big companies when they wouldn't want to. Welcome to the real world, though. Just it happens every day. Is it really that big of a deal, right? If that's your only justification for intellectual property, sorry, that might not wash. What if we're thinking about the overall distribution of benefits and opportunities in society? Does IP have anything to say about that? The progenitor of this whole line of thinking, gee, how do we fairly distribute all the stuff and all the opportunities in society? That's John Rawls, late of Harvard, and many of you know his work, so I won't go on at length. The other way that this topic comes to us, of course, is in concerns about not how much material wealth there is, but how it's distributed around, which is a Rawlsian concern. But in the last year or so, we've seen a lot of attention specifically to distribution of income as one particular type of resource. And Piketty's book, of course, was the sort of hot topic in economics in 2014. And so the question from that point of view is, what does IP have to do, if anything, about the fair distribution of resources in society? What can we say about it? Well, I'll go back to the idea of converting some labor into an asset. Piketty notes that, man, people who have capital, they just do a lot better, right, than the rest of us. And it doesn't take a genius to see that. The best evidence of that is when you see the headlines about the investment banks and the private equity firms, they're having their bonuses, right? If you don't think there are outstanding returns for having capital as opposed to labor, just read those headlines, you'll know what I'm talking about, right? Having those assets, having that capital to move around, moves you into a completely different class economically. Piketty makes the point that as the returns to capital become higher and higher relative to labor, you'll see more and more of a dispersion. You'll see more of a divergence, right? The people who don't have are going to have less and less. And that's just not a good situation from a social stability point of view. So how do you break into the ranks of the truly wealthy? Right? A lot of times, you don't really break into it, you're born into it, right? Born with a silver spoon on your mouth in third base, etc. But in some cases, people can kind of make their way into that world. They can acquire assets or capital when they started with none. So what kind of situations do we see that are like that? especially in the entertainment industry, especially in situations where people build up really valuable intellectual property protected works. What I'm trying to say is that the entree into the high end of the distribution happens either with access to a bunch of capital or the ability to create a whole bunch of assets by yourself. Well, who can do that? You can't make money out of thin air, right? You can't just imagine that you're wealthy and be wealthy, despite what some people seem to think. Well, just talk to J.K. Rowling about that, right? There she is. She's sitting at her cafe 30 years ago, and she is contemplating writing some books. She doesn't have access to great wealth. Her parents are school teachers, librarians, stuff like that. Fast forward to today, simply put, she's loaded. And she makes a ton of money while she's in the bath, while she's lying in bed, while she's waiting for a taxi in London. The money's pouring in and she's not working. She figured out that trick of turning some labor, the work of writing up the books, into assets. She figured it out. I'm not saying everybody can be J.K. Rowling. I'm saying one of the few ways you can get into that game without already starting ahead of the game is through intellectual property. You think about the people who have built up fortunes. You think about the people who are named in the Forbes list of 500 richest people. There are people who were born to it. There are people who killed themselves moving up the corporate ladder to get to it. And then there are people in entertainment, people who are authors, people in the film industry, some musicians. They're the people who create assets that end up earning lots and lots of capital returns, starting really from nothing. And Rowling starts not with a bank book from granddad worth 20 million pounds. She starts with a blank piece of paper and a cool idea. Right? So what I'm saying is, in a world where distribution is becoming more unequal, any legal instrument that allows you to turn your work, which we all have, into assets that may have a chance to earn outsized returns, that's an instrument we want to encourage. That's an instrument where if you're concerned about distribution, we should care about that. And in this Piketty sense of how do we remedy this, there are lots of answers, right? And more direct redistribution, which is taking boom from that bonus on Wall Street and putting it boom into the hands of the subway conductor. That's one way. But permitting people to create valuable assets is another way, and it's also a way that seems to be politically often more palatable, because at least you are creating it yourself, and it's the market that is essentially redistributing, rather than any kind of government visible hand that's actively redistributing. So something to think about: does IP have a place in a fair society? Is it a fair instrument? I think it has an important place. And if you look at the world of people who've become wealthy through their own labor, usually IP is somewhere in the background. I'm talking about the Kanye West. I'm talking about the Bill Cosbys. I'm talking about the Tiger Woods. Most of his wealth is branded. And J.K. Rowling, my poster child. Okay. It's not the real world for most of us, as we know. So let's go to the real world. When you ask people, what kind of digital content would you be willing to pay for? And so now we're moving from the very high end, the J.K. Rowlings, to the much more prosaic world of somebody who just wants to be a guy or a gal who makes a living doing some kind of creative work, right? It would be great if I were J.K. Rowling. I'm probably not going to make it. Can I make a living doing some kind of creative work? Well, you start with some pretty stark facts. When you survey people, and Pew Research folks did, you come up with this information. Which kind of digital content would you be willing to pay to access online? You first start over on the right, and the biggest bar on the wall is more than a third of the people say nothing, none of the above. The digital world is inherently free, right? Should be, has been. I will make it and continue to be through my own behavior actions. That's the world of information wants to be free, and I want to encourage it. I want to encourage that freedom by doing my part. Right? Okay, what about the other bars? Nah, it's not looking too good. Only a little over 20% for most of these things, ebooks, music, and stuff like that. So that's the landscape you face when you're sort of setting out. You say to yourself, wow, you know, only a quarter of my potential audience is even willing to pay anything for what I do. Ouch, you know, that sounds like a painful reality. It's not quite as bad as it seems, though, for reasons that we will see. That set of graphs certainly supports the first tier in this little three-tier model. There is plenty of demand for free stuff. And if any economist will tell you that's pretty much a redundant statement, right? That's kind of axiomatic. Zero price, infinite demand, right? We've seen the curves. But the market for content is a little more variegated than that. So let me sort of go through the three stages. People often start on stage one, just giving stuff away, right? That's the YouTube amateur distribution model. This second tier is an increasingly interesting one, and there are all kinds of experiments going on in that tier. And that's really the world of indie or self-publishing or self-distribution, where you get all kinds of dedicated websites and all kinds of small communities that are trying to create some kind of a sort of semi-profit model. And there are tons of experimentation going on in that. I'll talk about that a little bit. The basic idea usually is that, a la that 1996 dream world, we will disintermediate the big players, but we will re-intermediate with a very artist-friendly, typically sort of mom and pop or at least small scale, indie-oriented distribution platform, right? It's not your grandfather's record label, it's not one of the big publishing houses, but it is something designed to create some compensation in an artist-friendly way, right? That's an important tier because there's a lot of experimentation going on. And then there's the final tier, which is the household names, the old and the new household names. And that's really the world of premium content, where we see a lot of effort put into constructing paywalls and maintaining paywalls, meaning prevent access unless you pay. And we also see there the highest quality content, usually sort of the gold-plated content, the most expensive to create, and for which there's the greatest demand. Right? It's also where you see a lot of hacking, and you see a lot of attempts to circumvent. But the business model is to put some real effort into creating a pretty stiff paywall because you think the product is worth it. Right? That's the last of the three tiers. Okay. We have to distinguish between different types of content. I'll talk a lot about music because there's a lot of good examples there. But you should know that music is in some ways a special case for obvious reasons. The entry barriers, the cost of entry in the music industry have gone down quite a bit. You can essentially have a pretty decent recording studio in your bedroom or your garage anymore. And a fair number of people, that's where they record. You don't need to go to some studio in London or Hollywood that has all these big glass windows and long-haired guys with these sliding pots and all kinds of posters up that Jimi Hendrix played here and you know, everybody else played here. You don't need that anymore. You know, your bedroom or garage can work pretty well. That's obviously not true, at least in the high-end film business. For films that really look like they have decent production quality, it's still pretty expensive. So the economics of this are a little bit different from sector to sector. So keep that in mind as I talk a little bit about music here. You can get lots of free music in lots of places, and everybody knows this. And in these cases, I mean really free, not even forcing you to watch an ad, not even forcing any kind of a teaser until you pay a subscription later. I mean free, free, free. Absolutely and totally free. So this is music that people put up explicitly and make it public domain from the moment of its creation, for their own reasons, right? And it's not that people couldn't copyright their music, it's that they choose not to, or they choose not to enforce them. They basically waive their copyrights. As everybody knows, that's an easy way to get your music out there. If what you care about is building an audience and having people listen to your type of music, that's the easiest and cheapest way to do it, is just put it up for free. Getting somebody to pay attention to it is a different story, but at least your initial distribution decision make it free. Okay? The next mini tier is sort of ad-supported streaming. It's not quite free, but it certainly seems like that to most musicians because they don't get very much from it at all. And Irene and I were talking about this today. There's some famous examples. Songs that are extremely popular that earn pretty much next to nothing by the artist standards. And it's not that, you know, Spotify is sort of inherently evil or wrong. It's that the model right now is just not very lucrative for musicians. So when you go to music sites, you see a lot of stuff like this. I want to be a musician. What kind of day job should I get? Because I know that being a professional musician off the bat is a real steep proposition. And they talk about different jobs. You'll be happy to know paralegals get a good vote because it's clean, pays pretty well, and according to some people on the site, we have a little time to write music. So law firm partners here, you didn't hear that from me. One of the things that people care about, whether they put music up for free or not, is getting credit for the work. And one of the things that intellectual property law should do better than it does is pay attention to this need for attribution. Don't really have time to go into it, it's a little bit off topic, but even when you put music up for free, most artists would say they really, really value having their name associated with it. Right? If what you want to do is build an audience, you just want to get credit for playing music well. It's necessary for your name to tag along with the music, or you don't get any association with it, you don't get any benefit. We're not as good about that as we should be. We're not as good about that as some European countries. We really need a better and stronger right of attribution, even if you don't care about compensation in a monetary sense. When you interview artists, they all say they value attribution highly. And this is a result that spans not only interview data, like this book, which was an excellent recent book, but also experimental data. When you do experiments with people, and you basically say, how much is it worth people in an experimental psychology setting to get credit for their stuff? It turns out quite a bit. So it's a pretty robust finding. Any way you look at it, people like attribution. We need to do better on that, whether it's free or not. Okay? Let me talk about that middle tier now, because this, again, is where a lot of experimentation is. So the first entry point is just giving stuff away for free. But if you have any aspiration at all to actually make a living, you've got to make a segue at some point. You've got to make a transition to some other way of doing your business. You can't live on the air. Now, sometimes the first step on this is just asking people for sort of voluntary contributions. So it's sort of free plus. But there's a different way of going about that, which is this sort of self-publishing model. And the way this typically works is people will put their works up in an artist-friendly setting. The artist-friendly setting is not nearly as capital-intensive as a traditional intermediary, like a record label or a broadcast company. It's usually much more bare bones. But on the other side, the artist gets a much bigger percentage. So you basically get a much bigger share of usually a smaller pie. But sometimes that can be enough pie at least to get by. And some artists can make a living on this sort of model. So what kinds of examples am I talking about? A good example is this website, a company called CD Baby. And these guys have really taken a big bite out of the traditional music industry. Because for a lot of musicians, they would prefer to sort of do it themselves with a low-tech, straightforward CD production or online distribution from a company like CD Baby. And some somewhat household names, like Dr. John, has sort of switched to this model. He's almost a household name in some households, I would say. But the point is that these guys have replaced, to some extent, the Atlantic Records and Sony Records for at least some artists. They're not as well known. I venture to say a fair number of you have never heard of these guys. But if you're really into music and you want to go and find a new band, places like CD Baby are increasingly the places where you might go to do it. And know that when you download from them, they charge much less than the big record labels, but the artist gets a much bigger percentage. So a CD might cost, I think I got some, it's about a 50-50 split. They're also moving into YouTube and becoming one of the partners with YouTube for ad-supported, high-quality content on YouTube. And also, they do backing music for apps, too. And they have business models for making some money on that. I thought I had a cost figure. they sell essentially CD-length pieces of music for $5 or $6, maybe $7. So a lot less than the 12 or 16 that you might pay for a physical CD or for a full album on iTunes. Okay. Again, it's indie publishing because it's kind of low impact and it's fairly low overhead, but it's a bigger share for the artists. Here's a music video site that has the same exact strategy. Rather than go through a high production music video site, it's a little lower production, but it's 50-50 split, as opposed to a 10% royalty, which would be more typical. There's some interesting developments on the sort of high end of the model. I don't really have time to go through this. It's a complex point that Professor Garcia makes from Colorado, but suffice it to say that for very big artists, they can move out into sort of their own brand and their own channel, and they really can, in a sense, transcend any of the intermediaries. And the deal she talks about at length is this deal that Taylor Swift signed. As you know, Taylor Swift also pulled out of Spotify. So she is somebody who has enough clout to sort of write her own, I can talk about that, to write her own sort of contract. That's only true for a very few number of people. So the typical progression now would be, you start out, you have your friends, you play at the junior high, you have your band, you distribute your stuff for free. Okay? If you start to get any kind of a local following, any kind of a regional following, you might put some of your best stuff up on CD Baby and continue to give away some of your old stuff or give away some of your not quite as good stuff. If you get lucky, you may migrate to that very high end, the premium content. You may sign a traditional record deal. There are far fewer musicians signed than there used to be because the record labels are a lot leaner and employment in that industry has plummeted quite a bit. But there are still new bands who are signed. When you get into that world, you're into the world of premium content, paywalls, and a sort of high enforcement. But that's the end now of a long chain. It's not the beginning of your career when you sign your record deal. It's sort of the culmination of your career. And so you have a world where there's more steps on the ladder and there are fewer people at the top. There's debate about whether the total amount or quality of music has changed or whether this new variegated world is just giving us a different type of access to music. But from the creator's point of view, most of them experience it as a more challenging and a more difficult world because a lot of these kinds of steps require more initiative, more effort, more stuff to figure out, more strategizing they didn't have to do in the past. Okay? There are a lot of efforts to leverage traditional platforms that already have a good brand and maybe already have a good paywall. And probably the best example of that would be in the newspaper industry, right? The circulation for most newspapers has dropped quite a bit, and many of them, as we know, have died and gone out of business, right? The newspapers continue to experiment with the right way to price their content. And Financial Times just kind of redid theirs again with a sort of very low teaser rate and then a subscription sort of balloon payment, you might say, at the end of that. The idea also, is percolated up to the New York Times. If you're a subscriber to that, everybody gets a certain number free. That's the free content where they essentially waive their rights to get people to start reading, to get them interested in the content. And then once people cross a certain volume threshold, they try to get them to be paid subscribers. They try to say, boy, you're a big-time reader, you're reading more than your 8 per month or whatever it is, now we want you to subscribe, right? The point is these are well-known brands and well-known content sources. They're trying to leverage their long history of terrestrial success, they've always been a physical paper, into a business model that makes sense online. And they're doing it in a premium content, high paywall world. But notice there's a free component too. In the media business, what they call the free front porch. So you're walking down the street, you get a little free stuff on the front porch, but the good stuff is in the door where you have to pay to get in. Right? And so a lot of premium content companies know that they have to give some away. The debate inside these companies is pretty fierce. How much of a front porch? How much of a back end? When do you cross that threshold and how much do we charge? Those are still things people are fooling around with in purity. Right? The digital subscribers are growing, so something they're doing is at least keeping them, they're at least slowing the rate of decline, is how I would put it. Right? Now I want to talk about that reintermediation point, and this really is about the third tier. So you have traditional legacy companies like the New York Times. They're trying to migrate to the digital world. But a lot of the action in this third high content, high cost, premium content tier, a lot of the action is with new platform companies. And they're really the new intermediaries. They're the re-intermediaries. And the reason that they have clout is that they have successful models for securing payment, right? They are digital distributors. They have digital content presences. But they have effective walls that allow them to charge actual money for content. That's what makes these new intermediaries successful and powerful, right? So who am I talking about? I'm talking about the iTunes of the world. I'm talking about Netflix. I'm talking about Comcast and their online presence. The migration of these companies from just distribution pipelines into original content creators is happening fast, right? It's happening fast. If you think about why are they able to do it, it's because they have that effective paywall. They have a way to get payment for premium content. They have it built into their model. And that turns out to be the valuable asset, right? So the content will flow where it can get paid, which is as old as the hills. But the point is that's changed from a broadcast company that sells lots of airtime to national advertisers to a content company that has a successful website that draws a lot of traffic and that has an effective paywall. That's where the power is in the digital world, okay? But the point is, for content creators, it's a little like that Who song, you know, meet the old boss, same as the, meet the new boss, same as the old boss. And then they're younger, they don't wear ties, but they still call the shots, you know. They're not these old guys in Hollywood now, they're these younger guys in Palo Alto, but they're giving us about the same return on the dime, so it just feels pretty much like the same as what you'll sometimes hear. The effect on piracy has been interesting as a set of sources comes into play that have lots of content. We actually see that the whole kind of early, Napster, Grokster phenomenon may be changing course a little bit, simply by virtue of the fact that people always used to say, well, I'd be willing to pay if I could get my hands on it at a reasonable cost. And the for-profit online content distribution efforts of the record labels pre-Grokster, pre-Napster were horribly bad, notoriously bad. Now we have some mechanisms that actually work. And it turns out that at a reasonable cost, people sometimes would just prefer to pay if it's easy. Right? If the marginal cost is not that high, and if the content is of a higher quality, they'll actually pay. So when you talk to Taobao or Alibaba or Tencent in China, of course, copyright is very weak in China, and yet a fair number of subscribers to their online services will pay the premium rate simply to get higher quality content, typically music. So you can get any music you want online in China, right? You can't read the New York Times, but you can get any music you want. Which is more dangerous? Well, I don't know. It's not my country, so I'm not making the call. The point is, I don't know what the point is. Well, yeah, I lost it. Happens to me sometimes. Bear with me. No, the point is that if you look at these companies and you look at their actual practices, for them, just the ability to offer superior quality content is enough for most subscribers or some subscribers to pay. Okay? And that's a really effective kind of mechanism when you can pull it off, because that, for the first time, provides a pretty good alternative to free. In the Napster days, the content people used to say, how do you compete with free? And now, at least in some settings, people are saying, add some value, make it better, and then you can compete with free. It seems to work in some settings. The other place, if you think about it, that has an effective payment mechanism in place is in the mobile world, particularly in social media and chat, because they already have access to a payment mechanism. When you're in the mobile space, you almost always have some connection with the service provider, or at least an easy segue over to iTunes, which is on most phones, or some equivalent, right? So they have an effective, what we call micro-payment pipeline, meaning people are used to paying for little small amounts of content on their phones. And because they've been accustomed to doing that, that provides a stable pricing platform so you can actually get paid for content. And not surprisingly, again, where the ability to create a paywall exists, the content starts to flow there. So you will see this more and more. There are people who specialize, you know, if you have these online chat things, you can buy stickers, right? The service is free. You can text with your friends literally all over the world. So what's their business model? One way they make money is they sell these little icons, these little stickers. And people like them. They're fun. And not surprisingly, some artists have figured this out and said, you know, I can illustrate greeting cards for the rest of my life for $7.55 an hour. Maybe I can make a living doing some of these stickers, right? And you've seen them, they look like this. They come in these little series, and they're sort of, many of them are what I would call stylized, but we won't go into that. Some of them are what I call infantile, but I definitely won't go into that. So this company called Line, which is a big messaging service in Japan, Taiwan, places like that, they decided they would sort of create a marketplace for people who were going to do stickers, because there's a lot of demand. So they had a couple people doing them on a custom basis. There was a lot of interest, and they said, let's just throw it open and see what happens, right? And basically, you buy a set of stickers, 20, 30, whatever, for $1, essentially. Again, that's that micro payment model, right? What's the size of this market? These countries have very large populations. You don't have to sell an infinite number of dollar stickers to make a living. The market for stickers, shockingly, is $550 million, which sort of blows your mind. We think of these Japanese school children as always studying their calculus so hard, but I don't think they're doing that all the time. I think they're buying a lot of stickers in calculus class. Maybe we shouldn't worry so much. That's a $100 million market just for the secondary market, for this clearinghouse market for stickers, right? A lot of people use this marketplace because when you look at dollar transactions, this Line chat service was the largest online market, the largest non-game online revenue source, at least in 2013. And these illustrators are a good example of the kind of people I talk about in my book. They're just creative professionals. We're not talking J.K. Rowling. They just want to try to make a living. They want to get some cut of that $100 million market. And they specialize in these stickers because that's the way that they can do it. Now, they can express themselves. They can work independently. And they participate in this market, again, because they know there's a built-in payment mechanism. And that's really the point that I want to emphasize. And I want to end on this. I have more slides, but I know when I've outworn my welcome. You're not into the rebellion stage yet, but you're definitely well into the antsy stage. So if you want to have good memories of Burgess's talk, Burgess better shut up. The point is that the reintermediation has come from companies that have an established payment mechanism, and that drives a lot of the value. So for this third high-quality premium content tier, much of the battle that will go on will be about dividing the pie in those paywall settings. In other words, how much will the producers and the directors get for the Netflix original content? How much will people get for content they create on a custom basis for Comcast Xfinity? What share of the sticker market will the individual illustrators get? Those are the issues that will be fought, because that's where the online content creators will be going. And the pipeline ownership, of course, is necessary for an effective paywall to be established. But at the same time, a vibrant ecosystem requires lots of independent creators who are feeding the audience. And so if the pipeline companies get too greedy and people go elsewhere, then their online presence will shrink and the options for their users will shrink. So you like to think that some kind of market dynamics will help. On the other hand, the history of the entertainment business is not sanguine in that respect, right? If you know anything about it, we had to kind of sever theater ownership from movie studio ownership because this vertical integration play gave them way too much power. This is in the 40s and 50s. Antitrust may eventually play a role. When it comes to that, the difficult question is going to be, how do we take the collective interest of all the content creators and put it up against the ownership of the big fat pipes and the strong payment mechanism? How do we get a regulatory scheme that creates some balance if the market doesn't, right? That will be where the action is in that third high premium content tier. That's a little bit out beyond from where we are today. We're just in the process of moving to that road. But I think I did want to say one thing about the last topic, which I didn't really get to. Notice that to participate in this series of markets, this three-tiered organization, copyright and IP rights are extremely important. At the free level, of course, you have them but choose to give them away. At the independent level, you choose to retain ownership and try to strike an artist-friendly deal. At the highest level, you may concede ownership or hang on to it, but your IP rights is what gives you bargaining power against the owner of the pipeline or the platform. The point is that some people think that in the online world, we could do better than have copyright. We need to get rid of property rights. And they say, look at how much free stuff is out there. To that I say, yeah, it's great because people can have a property right and give it away if they choose to. But if we force them to give it away by taking it away from them, if we say, yeah, no more copyright, it's just not really effective anymore. Look what happens in that second tier. Definitely look what happens in that third tier, right? My point is, if you think about it as something that the creator, him or herself, has a choice over. Yes, I have copyright. From the minute I do this sticker drawing, from the minute I write this song, from the minute I create this documentary film, I own it. Now it's my choice whether to give it away, to put it up on an independent publishing site and get 50% of the proceeds, or to try to migrate to the top of the food chain and get 10% of a much bigger market. It's my choice what I'm going to try to do. The bottom line is that the property right, the copyright, gives you choice. It doesn't dictate that you have to try to go for that third tier. That's a mistake people often make. They say, if we give everybody copyrights, they'll enforce them to the hilt. No, they won't, and no, they don't. Right? Many people waive their rights and give them away. But if we take away copyrights, there's no way we can recreate the ability of the content owner to migrate up the food chain if we take away the copyrights. If we give them, they can waive them and give them away. If we take them away, they got no chance. And we're never going to get to a world where content creators have power again because we take away their ability to turn their labor into an asset. Isn't that where I started? Yes. Isn't that a good place to finish? Yes. I think we'll finish. Thank you. Going to mix it up, or are you going to say, game over?
I think we're just going to move right into the reception, and
Right.
people can come up.
That means I went too long. I'm sorry.
No, we started going, so people can come up.
Yeah, you can ask me questions while we
The story